This is the case of Lacbayan versus Samoy with the GR number 165427. Lacbayan and Samoy met each other through a common friend. Respondent, despite being already married, the relationship developed until petitioner gave birth to respondent's son. During their illicit relationship, petitioner and respondent, together with 3 more incorporators, were able to establish a manpower services company. 5 parcels of land were also acquired during the said period and were registered in petitioner and respondent's name as husband and wife. Eventually, the relationship turned sour and they decided to part ways. Both agreed to divide the said properties and terminate their business by partnership by executing a partition agreement. Respondent agreed to petitioner's proposal that the properties in Malvar Street and Don Enrique Heights be assigned to the latter, while the ownership over the 3 other properties will go to the respondent. However, when petitioner wanted additional demands to be included in the partition agreement, respondent refused. Feeling aggrieved, petitioner filed a complaint for judicial partition of the said properties before the RTC in Quezon City. During the trial, petitioner admitted that although they were together for almost 24 hours a day, respondent still go home to his wife usually in the wee hours of the morning. Petitioner likewise claimed that they acquired the said real estate properties from the income of the company which she and respondent established. Meanwhile, respondent testified that the properties were purchased from her personal funds. On February 10, 2000, the trial court rendered a decision dismissing the complaint of lack of merit. Petitioner elevated the matter to the Court of Appeals, asserting that she is the pro indiviso owner of one half of the properties in dispute. Petitioner argued that the trial court's decision subjected the certificates of title over the said properties collateral attack to contrary to law and jurisprudence. Unimpressed with petitioner's arguments, the appellate court denied the appeal. Issue: whether an action for partition precludes a settlement on the issue of ownership. In Municipality of Binyan versus Garcia, the court explained that the determination of whether or not a co-ownership in fact exists and a partition is proper, and in this case, petitioner is not entitled to have a partition either because co-ownership does not exist or partition is legally prohibited. The same is premised on the existence or non-existence of co-ownership between the parties. Petitioner insists she is a co-owner pro indiviso of the 5 real estate properties based on the transfer certificate of title covering the subject properties. Respondent maintains otherwise. Indubitably, therefore, until and unless the issue of co-ownership is definitely and finally resolved, it would be premature to effect a partition of the disputed properties. More importantly, the complaint will not even lie if the claimant or petitioner in this case does not have any rightful interest over the subject properties.
Created using Powtoon.